Hi and Assalamualaikum to Miss Nurul Shuhada and fellow friends. Today we will be presenting Hibah in Islamic finance. We will be presenting the introduction, following by the analysis, comparative analysis, issues, the progress or new update in the market, and the last one is the recommendation and conclusions. Hibah is an essential tool in Islamic financial management. Hibah occurs when a person gives his asset to another person without adequate consideration during his lifetime. Hibah can be defined as the transfer of property ownership from one person to another without payments, which is iwad, that occurs during the life of a hibah provider. It's regarded a tabarruk contract in its original form by given willingly, with no intention of praising anybody that performed by reciting an ijab and qabul or other similar terms. Hibah requirement and conditions composed by the settlers al-wahid, beneficiary of hibah al-mahwab lahu, asset bequeathed as hibah al-mahwab, and sigah, hijab, offer, and qabul acceptance. Firstly, the settlers must be an independent adult of reasonable intelligence who has reached puberty and is behaving responsibly. Ruj. The settler has complete control over the scope and quantity of hibah that he or she desires to give. Next, any person, whether Muslim or non-Muslim, can be a hibah beneficiary as long as the individual can receive the asset as an adult, which is mukallaf, or a minor by gift. The beneficiary must accept and own the asset. Moreover, the asset given as hibah must meet a few conditions. The asset must be halal and valuable enough according to Sharia law. The settler must be a legal owner of the asset. The asset is transferable and exists at the time of the hibah. Lastly, sigah is a verbal or non-verbal agreement or action that express the offer and acceptance of hibah's gift. For example, I give this gift to you, the settler state, or in the form of a hint or kinaya are examples of the clear expression of ijab. The practice for donating the hibah is encouraged among Muslims in Islam because it's advanced. The concept of Sharia maqasid in terms of flood protection and strengthening relationship with others. In Malaysia, Muslims commonly use the hibah instrument to plan asset distribution to intend beneficiaries in relation to specific assets. Conventionally, after the donor's death, ownership of the asset is transferred to the beneficiaries during the donor's lifetime or in certain restricted situations. The Hibah application has been expanded by supporting financial instruments inside the major Islamic financial services provided by several Islamic financial institutions in the current Malaysian practice. This is a commercial hibah that tied to other forms of principal shares based on the product or service contracts, such as a sale and purchase agreement, albi, lease, al-ijara, kafara, ar-ranu. Organization al-sharikah, savings al-wadiyah, and last but not least, profit or loss sharing al-mudarabah, which includes takaful products. Islamic financial organizations distribute hibah to their customers in the form of a reward, a dividend, or a special gift to encourage them to maintain depositing money in Islamic banking accounts. Unlike the advantages offered by conventional accounts, this practice is offered on a voluntary basis by specific Islamic banks and must not be personal interest. To ensure that Islamic financial institution use of hibah is compliant with Sharia law, Bank Negara Malaysia issued a particular reference on the use of hibah as a financial instrument that has been in operation since July 31st, 2018.
Assalamualaikum. I will present about the analysis of the application on Hibah in Malaysia. which is the legal perspective of the practice of hibah in Malaysia. Malaysia has permitted the practice of hibah in two ways. Firstly, for the assets wealth management, and secondly, for the Islamic banking products and services as a supporting financial instrument. With regards to the first application, hibah has long been applied and recognized as a means to distribute a Muslim's asset after his or her death. The first case that recorded the application of hibah was in the 1950s, where the issue of hibah was raised in the relation to the distribution of Muslim Malays' assets among the blood relationship, such as between father and son, husband and wife, grandfather and grandson, and so on. Distributing the asset between the family members, and that was made in accordance with the Muslim law of administration. The provision provides the jurisdiction and power to the Sharia courts in each Malaysia state to handle the matter that includes the classical hibah practice. The second type of hibah can be referred to as the modern concept of hibah, and it is applied as an Islamic financial supporting instrument for the Islamic banking and takaful products and services as offered by Islamic financial institutions. The hibah is also known as commercial hibah due to its function and purpose as a financial instrument in the Islamic financial system. Giving hibah is always subject to the Islamic financial institutions on discretion based on condition by Sharia requirements. This is because, in general, the practice of hibah as a financial instrument has been permitted by the Sharia Advisory Council of Bank Negara Malaysia. It is observed that a hibah can be applied together with other contracts which are being offered at the banking and financial institutions, such as sale and purchasing, albay, lease or rental, al-ijarah, company or business, al-sharikah, kafalah or guaranteed contract, al-rohan, saving or investment, al-wadi'ah, and loan or borrowing card. That's all from me. Thank you.
Next, I will present about hibah in takaful industry. The hibah instrument has also been used in the takaful industry in two ways, either by way of direct hibah or conditional hibah. In a direct hibah, the takaful company will structure and offer a takaful product to its takaful participant, whereby takaful benefit will be surrendered to the hibah recipient upon the maturity of the takaful certificate. Under the concept of hibah, the beneficiary of takaful benefit may be the children of the takaful participant or the takaful participant himself or herself. The concept of direct hibah cover the educational plan, medical plan, and other type of plan offered by the takaful company. This is addition to the saving plan on behalf of the beneficiary himself or herself. As far as the direct hibah concept is concerned, this practice is allowed by Muslim jurists. Next, conditional hibah. The conditional hibah in takaful is made in respect of the nomination of takaful recipient by the takaful participant during his life as to who will receive the takaful benefit as an executor of the estate or as the actual beneficiary. This kind of hibah is enforced subject to the occurrence of the event. For example, the death of the takaful participant that prior to the maturity of takaful certificate. The practice of giving the conditional hibah in takaful is said to be benefiting the beneficiary, since all the payment sum or the benefit received can be directly given to the heir of the takaful participant without going through the faraid. The conditional hibah in takaful is taking the conditional element in hibah rukbah. For example, the transfer of ownership of hibah benefit or asset can be materialized upon the death of the netting party in contract. According to majority of Muslim jurists, the condition imposed is considered as void even though the arcade inter is valid.
For comparative analysis part, Hibah trust model can be compared with living trust, which is a conventional product. Living trust, also known as inter vivos trust, is a conventional counterpart that operates similar to the Hibah trust model, where it allows a settlor to put his asset into a trust during his lifetime. In the West, it is primarily set up to avoid probate, avoid estate inheritance taxes, preserve privacy, and manage financial affairs efficiently. For Hibah trust offer and acceptance is very important and must be conducted correctly between the donor, trustee, and beneficiaries with the presence of at least 2 witnesses. This is because it will become permanent, cannot be revoked after the delivery of the contract is agreed and announced. The Hibah trust can be revoked if the Hibah is between a father with a son and a grandfather with his grandsons. This is because after the delivery is made by the trustee to a beneficiary as prescribed in the deed, the donor will no longer have legal right to revoke the Hibah. Conversely, living trusts in this sense provide more flexibility as the principal contract is trust which generally can be revoked by the settlor at any time, as it is not permanent. For this part, the underlying contract in Hibah trust is Hibah itself and the concept of amanah, which is trust. The trustee has the legal right for a limited time once it is declared and will manage it based on the trustee deed. However, for a living trust, the concept of trust is much greater than the gift itself.
Transfer of asset. Eventually, when both Hibah and living trust are declared, the ownership of asset will be transferred to the trust where the trustee is responsible to lead and conduct the asset as stated by the deed. Usually, the asset under Hibah trust will only be delivered to the beneficiaries after the donor passes away. However, asset can be transferred to the beneficiaries in living trust during the donor's lifetime. The contract for Hibah trust will be dissolved once the trustee has delivered asset to the beneficiaries, but this is not the case for a living trust, which can be disbanded at any moment. Next, beneficiaries. Aside from that, the settlor of a living trust might identify himself as a beneficiary. Moreover, if he is not the only beneficiary, he may be named as the trustee who will manage the trust asset. In the meantime, the donor can name himself as one of the beneficiaries of the Hibah trust. Yet, appointing himself as a beneficiary under the Hibah trust may be pointless because if he passes away, his entitled portion will be declared estate and subject to the inheritance law. Consequently, the goal of identifying himself as a beneficiary under the Hibah trust is defeated.
Sharia court has jurisdiction over the Hibah. However, the method for transferring ownership of Hibah real estate must follow the process of the National Land Code 1965 and the grant recipient will get an uncontested title. According to the torrent system of the National Land Code 1965, the grantees' rights are unassailable once they are registered. The first case involving Hibah is Latifah binti Madzin versus Rosmawati binti Sharifuddin and Anor. In this case, the appellant has asked the court to determine that the joint savings account between them and the deceased is a Hibah from the deceased because the appellant has the right to use the money freely while he or she is alive. The money does not belong under the grant category according to the Civil High Court's ruling. The appellant filed an appeal with the Court of Appeal, arguing that the issue in this case is one of banking law and contract law involving probate, which the civil court has jurisdiction over. The court rejected this argument, ruling that the matter in question is hibah under Islamic law and thus falls under the jurisdiction of the Sharia court. The second case is the issue of real estate hibah, and withdrawal of real estate hibah is discussed. The plaintiff in this case is Fah binti Abdullah, who has 7 children. 5 of them are the result of her marriage to her first husband, and the other 2, both defendants, are the result of a marriage in which her second husband made a grant transferring land to both defendants. Plaintiff then met with her lawyer to construct a grant agreement which was signed by all 5 of his children with the exception of 2 defendants. The plaintiff has launched an action after reaching a dead end due to the defendant's failure to relinquish the land to be subdivided with his other 5 children.
On March 6, 2020, Lembaga Tabung Haji has postponed its hibah announcement pending a green light from the new Prime Minister Tan Sri Muhyiddin Yassin. Under the Tabung Haji Act 1995, the Pilgrims Fund is required to get the approval from the designated minister in the Prime Minister's department before declaring a hibah. According to the latest Federal Government Gazette, Ministers of the Federal Government No. 2 Order 2020, Muhyiddin will be in charge of all ministries and government departments until the appointment of cabinet ministers. On December 2019, Tabung Haji said it was anticipating a higher dividend for its financial year 2019. At the time, Group Managing Director and Chief Executive Officer Nik Muhammad Hassyuddin Yusof said the fund's financial performance had been very positive in the third quarter of 2019. He also said that Tabung Haji has stayed on the right track on September 2019. For financial year 2018, Tabung Haji declared a record low hibah of 1.25%, which amounted to 913 million ringgit for its depositors. Then, Minister in the Prime Minister's Department, Datuk Sri Mujahid Yusof Rawas, had said that the lower dividend was due to mismanagement under the previous Barisan Nasional administration. Comparatively, the Pilgrims Fund paid 6.25% as hibah in financial year 2017 to depositors who had not performed their pilgrimage and 4.50% to those who had. On February 2020, the Ash Financial Daily reported that Tabung Haji is planning to remove its subsidy for first-time pilgrims, except those in the bottom 40% income group B40, from next year onwards. Tabung Haji has been subsidizing first-time pilgrims, including those accompanying them, for years. It has spent over 1 billion ringgit on this in the past decade. In 2019, the cost of the Hajj pilgrimage subsidy borne by the fund amounted to 400 million ringgit, according to the reports.
Recommendations and conclusion. According to the issue that have been discussed earlier, Islamic estate planning through the practice of hibah is the major issue that needs to be solved. One of the major recommendations to overcome this problem is through organizing an awareness campaign to the people who want to practice hibah. This awareness campaign needs to be conducted by the specialists from any Islamic corporate entity. This is said because the specialists from Islamic corporate entity will be able to explain the full process on how hibah works when it comes to Islamic estate planning, as there will be many strategies taught to the people. By educating the society through organizing awareness campaign, planting good values in the societies should be corporate entities' main objective other than generating profit. By educating the societies with the exact and correct information, this will increase the confidence and trust towards hibah. That will be a guidance for them to plan things ahead, where people will be able to choose the right channel to make placement of their money according to their expectations. The next effective recommendation to overcome this problem is by looking for alternatives and creative solutions. This is said because there are many estate planning professionals questioning the head of the family on how he wants to divide an estate or property among the children. The estate planning professional normally gives an option to the head of the family to either split the estate or property equally or according to the financial needs of their children. This scenario clearly shows that the estate planner creates a critical situation to the family head to make decisions immediately which might not be favorable to the head of the family. The head of the family needs to take a rational decision which will benefit himself and his family. The recommended method to overcome the problem is by splitting most of the estate or property equally according to their children's needs and put the rest in a trust or even invest it in a long-term insurance which will accumulate interest that will be beneficial to the head of the family in the future. In a nutshell, the practice of hibah is one of the Islamic wealth management methods as it has become a guidance for the benefits of public society. However, based on the issues related to hibah, it is known that there are few constraints in implementing hibah as a normal practice. This is because there are still an absence of specific guidelines or procedure of hibah governance. The practice of hibah till today is only depends on the general information from the hibah standard, and it includes the juristic opinions which became a conflict between each other. In order to overcome as a whole, the authorities should come up with a clear framework or standardized law which is related to hibah. This really helps to solve complications regarding hibah that will take place in the future.